Hearing the appeal, SAE Education Limited against Commissioners for Her Majesty's Revenue and Customs.
Yes, Ms. Hall.
May it please the Court, I appear with Elizabeth Kelsey on behalf of the appellants, and Mr. Surabjit Singh is here on behalf of the respondents. If I may start by outlining the order of the submissions I propose to make, subject to the convenience of the Court. First is the question of the Finance Act 1972 and the Education Reform Act 1988, and why it is that they do not justify the constituent part of test. Second, I will develop our case as to why the focus of the relevant test must be on the provision of education as opposed to the formal governance, constitutional or contractual documents, structures. And finally, I will address relatively briefly, because this issue has been addressed in some detail in our printed case, as to why we say the first tier tribunal was entitled to reach the conclusion that it did, namely that SEL met the integration test based upon the provision of higher education to students. So if I may start with the first of the three subjects, namely the Finance Act 72 and the Employment Rights Act 1988, I will deal with them in turn. Could I just remind the Court of the context in which those legislative provisions fall to be considered? This is our third ground of appeal, namely that the Finance Act and the listed bodies order made under the ERA cannot justify the constituent part of test. Both of these provisions feature prominently in HMRC's printed case. In general terms, the Education Reform Act took control of higher education away from local authorities and gave it to educational institutions, and so far as material to this case, introduced the regulation of bodies providing higher education. If I may start by looking at the questions around the listed bodies order and how those orders were treated by previous tribunals and the Court of Appeal. The upper tribunal did not mention SEL's listing in the listed bodies order. The first tier tribunal disregarded it on the basis that the question for determination was whether SEL was a college of a university within Note 1B, not whether it was a college within the Education Acts.
Do you dispute that proposition?
I do not.
You don't?
So paragraphs...
You said you did dispute it.
I do not dispute that proposition,
you
no.
don't dispute it.
Paragraphs 194 and 261 of the first tier tribunal's decision expresses that view, which is the same as the view expressed by Mr. Justice Burton in the SFM case at paragraphs 21 and 22 of his judgment. I'll come back to this point, but at paragraphs 67 and 68, the first tier tribunal described how SEL was listed in the listed bodies orders of 1999, 2004, 2007, and 2010. Now, with regard to the Court of Appeal, both parties submitted that because the Education Reform Act and the listed bodies orders served quite different purposes, they were not an appropriate aid to construction of Note 1B. But despite that, Lord Justice Patten, in particular at paragraphs 12 and 13 of his judgment, disagreed with those submissions. It's at paragraph 12 that you see Lord Justice Patten's classification of Oxford and Cambridge universities as federal universities, which we say is a wrong categorisation of those universities. He also described those universities as the most obvious examples of universities operating on a collegiate basis. And having briefly described what his lordship considered to be the more pertinent aspects of the governance of Oxford and Cambridge universities, he concluded at paragraph 12 that the colleges of those universities were an integral part of the structure of the university. by which I take that to mean that they were a part of the governance structure of the university, since that is the context in which he makes that comment. Paragraph 13 of the judgment is really the key paragraph, where his lordship says that the system that he had described, namely the system of governance in Oxford and Cambridge universities, was, quote, mirrored in the listed bodies England Order 2010. And although, to be fair, at paragraph 18 of his lordship's judgment, he pointed out that the listed bodies order is simply a useful illustration of how the statutory language had come to be interpreted. It nevertheless is clear, I would submit, that that order and its vires formed a central part of the Court of Appeal's reasoning. The Education Reform Act is in the authorities' bundle, and because I propose to identify, I see 6 major difficulties with relying upon the Education Reform Act, it may be convenient for the court to turn it up. It can be found behind tab 3 at MS 1705. The relevant section is section 214, and the court will be familiar with the fact that in general terms, this part of the Act is concerned with criminalising the grant of degrees by persons in the course of a business. That is section 2141.
Yes.
However, crucially, section 2141 does not apply as respects anything done in relation to authorised, permitted, or recognised degrees. And of course, it's the listed bodies' orders that recognise certain qualifications for that purpose. As to the difficulties of using section 2114 and indeed section 216 as a reference point for interpreting note 1b, is first of all that the legislative scheme is concerned with the grant of awards described as a degree, or which purports to confer on its holder the right to the title of bachelor, master or doctor, and may reasonably be taken to be a degree. That is section 2141. So far as material to this appeal, the education exemption, on the other hand, for VAT purposes, is concerned with something quite different, namely the provision of higher education, which is a far broader concept than the granting of an award. The granting of an award is not an activity which has been singled out by the principal VAT directive as being in the public interest to exempt. And indeed, as the court will have noted from the passage from Horizon College, which is quoted at paragraph 63 of our case, the concept of education is first of all an autonomous EU law concept, and secondly, it is very broad. And as you will see from the quote at paragraph 63 of our case, the European Court has said in terms, at paragraph 26 of the Hedera case, that the concept of education is not limited to education which leads to examinations for the purposes of obtaining qualifications.
So it would extend to a research institution.
I'm sorry?
It would extend, would it, to a research institution?
No, it would not, my lord, for this reason. There was a case called EC and Germany, which is cited in our grounds of appeal, in which the European Court found that to include research activities of universities within the scope of the education exemption was ultra vires, since the education exemption is limited to the provision of education. So this is significant when it comes to assessing the principles of fiscal neutrality as an interpretive aid, which I will do in due course.
Right,
But
so All Souls College,
no
Oxford, for example, is not engaged.
I'm so sorry?
All Souls College, Oxford, is not engaged in the provision of education by this test, is that right?
It would be so engaged if it were to provide education.
Well, if it doesn't teach undergraduates, though some of its fellows do as individuals.
Yes. So insofar as there is teaching at All Souls, then there is an entitlement to the exemption. It would be a fairly arid exercise to classify an organisation as an eligible body if that organisation never intended to or had never made supplies of education. And this is an important point my Lord raises, which I will come on to in the next stage of my submissions, which is that it is quite wrong to hermetically seal the concept of an eligible body from the activities in which it is engaged, since an eligible body's status depends upon the similarity of its objects with bodies governed by public law, namely the provision, in this case, of higher education. So the activities of a body and the activities in which it is engaged are inextricably linked for the purposes of identifying whether or not that body has eligible status. So going back to my Lord's question with regard to All Souls, and the same could be true of some Durham colleges, which are essentially residential colleges. If any of those colleges chose to or had made supplies of higher education, then they would be eligible.
The answer in both the residential colleges, the purely residential colleges, and institutions like All Souls, which as institutions only do research, is no, they're not eligible.
In the context of claiming an exemption to VAT, which is the only context that matters, clearly All Souls is a college of Oxford University.
Yes, but it doesn't, as a college, provide education.
Quite. But the concept of an eligible body under VAT law must be driven by Article 132 and the policy objectives underpinning it, which means that the approach should focus upon the activities in which that eligible body engages, in addition to its domestic law status as a college of a university. In other words, the concept of an organisation which has similar objects to bodies governed by public law providing higher education is not one and the same as the words which you read from either Note 1B or what you might read in literature from All Souls College, Oxford. And this is a central part of our case, and it's the second subject which I propose to expand upon, if I may.
It occurs to me that although the first item listed in Group 6 is the provision of education, it goes on to list various ancillary matters, for example, the supply of any goods or services which are closely related to the supply of education. So if you have, for example, a university like Durham, which is a very large university in a small town in the north of England, the residential colleges are providing the accommodation and meals which students require if they're going to attend the university in order to receive an education. On one view?
It could be said, my Lord, if the issue were to arise in the context of an exemption for VAT, that the provision of accommodation for students is an integral part of their education. That could be argued. It's a point that's never been argued to date. But what I would say is that the EU law concept of education is extremely wide and more than capable of accommodating the notion that the provision of accommodation can fall within its remit.
But if you provided research, as many university institutes do, for payment, you would not be exempt. I mean, I'm not suggesting that this is a surprising result. I'm simply trying to clarify some boundaries. I think that is effectively your submission.
That's a taxable supply.
Would be a taxable supply not within the exemption.
That's right. And until relatively recently, our own Value-Added Tax Act exempted the provision of research by higher education institutions. And it was as a consequence of the EC Germany case that our legislation was amended. Now, as the court recognised in Horizon College, the references paragraphs 24 to 26, adopting too narrow a definition of education risks creating too great a divergence between member states in the application of the education exemption. And just a word of warning, both Horizon and Hedera, which are cited in our printed case, share one Advocate General's opinion. The second difficulty is that the Education Reform Act is a purely domestic provision. By contrast, it's common ground that education is an autonomous EU law concept, as indeed is the concept of an eligible body, which is not a purely domestic law concept.
But forgive me for interrupting you. Can you give me the name of the case that you referred to about research?
EC Germany. It is cited in our grounds of appeal. I'm so sorry, I thought Miss Kelsey had the reference.
Okay.
The case number here is C237 2000. Is that 237 or 287? 87 2000. Thank you.
Thank you.
The third difficulty is that the crime, as we see from section 214, captures any person who in the course of business grants a relevant award. First of all, note 1b is limited not to any person, but so far as material to this case, a UK university. And of course, any college, institution, school or hall of university. So the crime only captures those who grant the relevant award in the course of business. By contrast, note 1b, for the reasons given in paragraphs 35 to 37 of our case, is necessarily only concerned with supplies of education made in the course or furtherance of any business carried on by a taxable person. Now, that domestic law concept reflects Article 9 of the Principal VAT Directive, which speaks of an independent person carrying out an economic activity. The key point here is that the two concepts are wholly unrelated, an Article 9 activity being a purely European law concept. The fourth difficulty is that Section 2142C excludes from the criminal offence such other awards as the appropriate authority, which is the Secretary of State for Business, may by order designate as a recognised award. Now, recognition under Section 2142C is only for the purposes of that section, and therefore manifestly has no value when seeking to interpret Note 1b. The fifth difficulty arises out of the order that was actually made, or the orders that were made under Section 2142C, which provides that a recognised award may be either a specified award to be granted by the person named in the order, or any award granted or to be granted by such a person. At paragraph 67 of the Tribunal's decision, we see that the SEL was listed on the basis that it provided a specified award, namely, as the Tribunal describes, quotes, courses in preparation for a degree. Courses in preparation for a degree, so it comes under the second line of 2142C. and I just ask you to note when reviewing paragraph 67 of the First Tier Tribunal's decision, the various ways in which SEL is described over the years. But what's of note here is that SEL is not listed under section 2163B as a constituent college, school or hall or other institution of a university. But our primary point is that nothing of any value can be inferred from SEL's listing under sections 2163A and not 2163B for the reasons I have given. And it is notable in relation to all of the listed bodies' orders that the colleges of Oxford and Cambridge are not listed as constituent colleges. They are listed as, quote, institutions of a university. That is to say, under the second part of section 2163B and not the first being a constituent college, school or hall. In other words, the Secretary of State for Business has taken a quite different view to that expressed by His Lordship, Lord Justice Patten, with regard to the universities of Oxford and Cambridge. The final and sixth difficulty is that Note 1B is concerned with a UK university, which is not defined. By contrast, the Education Reform Act applies, as far as universities are concerned, to recognised bodies, which is a concept defined by section 2164. And such a body requires authorisation to grant awards under the Higher Education and Research Act, and may be a body permitted to act on behalf of an authorised body, or can be a body within sections 2142A or B, namely a body authorised by Royal Charter or Act of Parliament to grant degrees. So the short point here is that for the purposes of interpreting Note 1B, a UK university cannot be regarded as the same as a recognised body as defined in section 2164. I would invite the court to note that it is the university, in this case Middlesex University, which provides the Secretary of State with the information he or she needs in order to list the organisation in question. That is recorded in HMRC's own information sheet 0310, which the court will find at Part 1D, Tab 19, MS 1563. Now, before moving on to the Finance Act, could I just spend a few moments dealing with MU's own articles of government? Those articles, I think it may be worth convenient for the court to turn it up. They are in the core volume behind tab 7 at MS 326. And it is Article 3.3 which is of interest, because what this does is to set out the responsibilities of the academic board. And what I'd ask the court to note is the last line of 3.3a, which is that such responsibilities shall take account of the requirements of validation and accrediting.
So which page, MS
MS
page?
327, 3.3 at the top, the academic board. And it's the last line of 3.3a, which sets out the various responsibilities of the academic board which are, for the court's note, described in the MU handbook, which occupies the whole of Part 1B. But of note here is that the responsibilities of the academic board shall take account of the requirements of validating and accrediting bodies. Of course, that tells us nothing about whether that means that it is possible to create a college of a university for the purposes of Note 1B. But I draw this to the court's attention, first of all, because it's directly relevant to the power that was being exercised by the university, but secondly, to make the point that these articles of government were made pursuant to the instrument of government, a better copy of which I hope the court received on Friday.
I'm not sure that we did, Ms. Hall.
I don't have it.
We do. I'm not sure we need to turn it up, but essentially, an instrument of government must be approved by a Secretary of State, insofar as it is an instrument of government of a university. And what that instrument of government does is to authorise the setting up of an academic board and empower the university to set out the responsibilities of that academic board, which you see in the Articles of Government, to which I have just made reference.
Is this sometimes referred to as franchising?
It's quite different to franchising, my lady, quite different. Franchising is where you are authorised to use a course which has been created by somebody else and no more. And you will see in MU's handbook in Part 1B that the handbook makes a very clear distinction between franchising on the one hand and validation on the other. And that is a central part of our case.
Yeah. The instrument of government, although it's not copied very well, it looks as though it's a document authorised by the Privy Council under statutory powers.
Quite. So it's at MS 333, and it's regrettable that the court didn't
I do have the good copy. It came as a separate,
Yes.
E attachment.
Yes. We do have copies here, if it would help.
Yes?
On the 26th.
So what the court will note from that is that this order from the Privy Council essentially makes the instrument of government for Middlesex University pursuant to its powers under sections 124A3 and 4 of the Education Reform Act. And you see that from the recitals. And the academic board you will see at page 334. And just underneath the academic board, there's the instrument, which means the instrument of government we are looking at. And the articles means the articles of government, to which I have just made reference at MS 327, which begin at MS 325. And the point here is that those articles of government were endorsed by the Secretary of State via this instrument of government. Now, why do I take the court to this? This really relates in part to the schedule to which reference is made in our printed case, which is at Part 1D, tab 22, MS 1649. And what this does is to cross-reference, virtually on a clause-by-clause basis, the 2009 Memorandum of Cooperation with the university's Articles of Government. It's a relatively easy exercise. One looks at a clause in the 2009 MOC and indeed all subsequent MOCs and tracks it back to the MU handbook at Part 1B, which is itself knitted into MU's Articles of Government. In short, it is not right, we submit, to characterise the MOC as no more than a commercial arm's-length agreement reached between two independent entities. This is one of the many respects in which the activities of SEL are knitted into the governance structure of MU, although not as directly as Lord Justice Patton's test envisages. So if I may move on now to the Finance Act 1972. This is in the authorities bundle at MS 1699. To give you the context, our case on this is set out at paragraph 4 under the third ground of appeal. I won't repeat it, it's at MS 29. In terms of the First Tier Tribunal's treatment of the Finance Act, paragraphs 64 to 5 of its decision records my submission that Parliament had shifted its position since 1972 by requiring a looser nexus. That submission was based upon the fact that a college of a university was considered by Parliament to be part of the definition of a university itself, which implied that it was regarded to be one and the same as the university, as opposed to the wording which we now have in Note 1B. I don't abandon that point at all, but in fairness, I concede that it's not our strongest point. One can spend some time unpicking that submission. But it nevertheless remains as one of our grounds of appeal. We say the First Tier Tribunal rightly attached little, if any, weight to the 72 Act. You see that from paragraph 146 to 7 of its decision, where ultimately it noted that it appeared to be slightly broader in its effect, but ultimately the question was whether or not the link between SEL and the college was sufficient. The Board of Appeal, on the other hand, dealt with it quite differently. Paragraph 11 of the Court of Appeal's judgment starts with a recitation of Article 10 of the second directive, which, it is common ground, gave a very broad discretion to member states with regard to the recognition of exemptions. And what Lord Justice Patton concluded was that the Finance Act represents Parliament's view as to what should and should not be included in the exemption, unconstrained by what we now know as what Article 1321. There are a number of difficulties with that approach, the first of which is that it fails to acknowledge that the mar-leasing principle, set out at paragraph 14 of our printed case, applies whether the provisions being interpreted were enacted before or after the directive. And of course, the sixth VAT directive was implemented on the 17th of May 1977, which included the equivalent of Article 133 in the principle of that directive. You will find the equivalent of that in Article 13.2a. Therefore, Parliament must be presumed to have implemented Article 132a with regard to the 72 Act after the 17th of May 1977. So it is, we say, quite wrong for the Court of Appeal with respect to have characterised the differences between the Finance Act 72 and the VAT Act 94 as, quote, stylistic and grammatical. The differences, for reasons which I will go on to address, were profound. You have the points made in our printed case, and I don't repeat them here, but I wish to make some further points in relation to this. The first is that item 1B of Group 5, Schedule 5 of the 72 Act excludes the provision of education for profit. And when we get to Zimmerman, tab 15, and MDDP, tab 17, we will see that the question whether a member state has or has not excluded profitable organisations has a profound effect on the interpretive approach that one should adopt when interpreting domestic provisions. The second difficulty is that the 72 Act only identifies two providers, namely a school or a university. There are 8 providers in Note 1B. The Finance Act only talks about a university. The VAT Act is limited to a UK university. The concept of education, as defined in the 72 Act, is really quite different, namely education of a kind provided by a school or university. It's notable that item 1B of the 72 Act is in the passive voice, Parliament being indifferent as to who provides education of a kind provided by a school or university. It therefore applies to all non-profit making entities who provide education of a kind provided by a school or university. Education under the 72 Act is given a non-exhaustive definition. It includes training in any form of art. Compare that with the reference to education in the VAT Act, which of course is an autonomous concept, PC Horizon College. The concept of a university is also given a non-exhaustive definition in the 72 Act, which is missing from the 94 Act. The concept of a university college is engaged in the 72 Act, missing from Note 1B. The definition of a university includes the college, school or hall or university, not any college of a university, which we have in Note 1B. So for all those reasons, we say it is a false a comparison which yields nothing of any real value as part of the interpretive exercise. What the Court of Appeal then did in paragraph 17 was to compare the Education Reform Act 1988 with the Finance Act 1972 and concluded that there was an identity of purpose. We say that there is no such identity of purpose. Section 2163B of the ERA refers to a constituent college. You will find no such reference in the 72 Act. That's the first point. The second is that the Finance Act 1972 is not concerned with recognised bodies, as the ERA is, but with a university. A recognised body is a body that's recognised under the Education Reform Act, whether it is a UK entity or a foreign entity. The Finance Act refers to, quote, a university college, which is missing from the Education Reform Act. And in that context, there are many education acts, but it is notable that the Higher Education Act 1992 deals exclusively with the question, or deals in a very focused way with regard to the question of what a university college is. Now, why does this all matter? It matters for the reason given by my Lady Arden in paragraph 56 of Her Ladyship's judgment in the University of Leicester, which is behind tab 12 of the authorities bundle. In that paragraph, the distinction is quite rightly made between colleges which are a constituent part of a university, for example, the University of Wales, citing the Glazebrook article, and Oxford and Cambridge and Durham University colleges, which are separate from the university but interrelated. And that comparison was rightly made in order to make the valid point with which we respectfully agreed that there is no one way in which a college and a university can organise themselves, which gives rise to the need for a flexibility of approach. All UK universities are caught by Note 1B, regardless of whether they are private, such as Arden University, which is run as a profit, whether a distance learning is being provided, such as the Open University, whether they are collegiate, like Oxford and Cambridge, or collegiate, like Durham, whether they are specialist, like the Private University of Law, or LSE, or SOAS, whether they are a private limited company, such as the University of Law, or a charity, such as Oxford and Cambridge, whether they operate globally, such as Middlesex University, or whether they are spread geographically, such as Middlesex, and indeed universities such as Exeter and Durham are similarly spread geographically. It matters not whether the university is ancient, such as Oxford and Cambridge, or relatively new, such as Buckingham, which was founded in 1973, which then would have been excluded from the exemption by reason of the Finance Act 1972, which excluded profitable bodies. It also matters not whether the university is a federal university, such as the University of Wales or the University of London. The point here is that a university need not be, for the purposes of Note 1b, a university which has colleges which can be described as constituent colleges. Now, the Glazebrook article was mentioned by my Lady Arden, in her judgment in the Leicester case, and indeed was cited in our grounds of appeal. Now, we don't necessarily align our case to the position he adopts, but what is notable is that his focus is on Section 201 of the Education Reform Act, which gives certain powers to university commissioners in relation to the employment of research staff and teaching staff. And in that context, namely in the context of Section 202, the Act does draw a distinction between colleges in a university, which Glazebrook includes Oxford and Cambridge, because they have no power in relation to the university statutes. By contrast, there are constituent colleges of the university, which Glazebrook concludes includes the University of London, which is a federal college, and would have included the University of Wales, which used to be a federal college. It's an interesting read, and what it does is to demonstrate the dangers of dipping in and out of the very voluminous Education Reform Act, which has far-reaching educational policy objectives, which could not be further removed from the VAT system, which is a creature of European law. So those are my submissions as to why it is that neither the ERA or the Finance Act can provide any assistance to this court when seeking to interpret Note 1b of the Value Added Tax Act. Now, this brings me to the second of the third areas of our case I would like to develop, which is why the focus of the integration test must be on the activity comprising the provision of education, not on the formal governance, constitutional and contractual structures. In a nutshell, we say that the relevant test is whether a college and a UK university are sufficiently integrated in relation to the provision of higher education by the college to students. That is what we say the test is, and the SFM factors, coupled with a consideration of all the facts and circumstances of an individual case, are ultimately designed to meet that test.
Can I just ask you, I've just written down your test. Sufficiently integrated isn't really in itself a very clear test. What is it, sufficient for what?
Yes. This is what I'm just about to go on to address, my lord. But may I address your concern with regard to the word sufficient? The value-added tax system is full of rules which require an element of evaluation. To give you but two examples, to claim an input tax deduction, it is necessary for there to be a sufficiently direct and immediate link between an input and an output. To characterise a payment as VAT consideration, there needs to be a direct link between the payment going
But the point about that is that the the purpose for which it has got to be sufficient is identified in the instrument.
Precisely.
So what do you say is the purpose for which this has to be sufficient?
For the provision of education to students.
So any relationship on that footing with a university which involved the provision of education to students would qualify the institution providing it as exempt. Is that correct, according to your submission?
I'm here concerned only with colleges of a university, and I'm talking about the link that there must be between a college on the one hand and a university on the
But, I mean, are you submitting, I think I gather from your last answer that you're not, that if a body is sufficiently integrated with a university for it to be providing educational services in connection with that university's activities, that body is exempt? Is that how you bring the concept of sufficiency works in your submission?
Yes, it needs to be, the link between the college and the university needs to be sufficient in relation to the provision of higher education.
Well, forgive me for testing you a bit, but in relation to was once described as the broadest words of connection known to the law. I mean, are you really going to put it as broadly as that? Because it does seem to me to follow that if you do, any body which is has a connection with a university sufficient to result in the provision of educational services under the auspices of that university is exempt. Now, that's a very wide submission. It may be the one that you're making, or you may be putting it in more narrowly, in which case you might have to reformulate your test without the words in relation to.
Well, with respect, my Lord, first of all, that's an extremely pertinent question. But secondly, what's missing from it is the recognition that the organisation in question must be, relevant to this case, a college. And what Article 132 tells us we must presume Parliament intended to achieve was to recognise colleges of a university, because such organisations have the object of providing higher education.
The college simply means an association.
Yeah.
And the educational purpose of the association is derived from the context of this particular legislation.
Given that Note 1b talks of a college, school, institution or hall of a university, I would submit that it matters little as to how the descriptive label that you apply to the organisation in question. What matters is that the college, which in this case it is Common Ground SEL, is providing higher education in a manner, it's engaging in the activity of providing higher education in a manner which is closely integrated with the university.
Well, I mean, this word closely integrated,
Yes.
what we're looking for is some test
Yes.
by which you discover whether something is closely integrated. And
Yes. My case, my
what
Lord,
is that test? I mean, you may be submitting that any outfit that provides educational services for the purposes of a degree issued by a university is an exempt body within this test.
I don't go that far, my Lord. The college in question must have as its object the provision of higher education. And you discern...
That's a test that would be satisfied in all the entire category that I've just mentioned.
So a central part of our case is that you do not identify the objects of such an organisation by reference to its constitution, such as its memorandum and articles of association. You infer what its objects are from its activities. And in that context, what we mustn't lose sight of is the fact that Article 132 is one of the exemptions of an activity in the public interest. The European Council, having identified the public interest need articulated in EC Germany to relieve students of the VAT burden they would otherwise suffer in receiving higher education. So the European Council has given member states a discretion to recognise organisations with similar objects to bodies governed by public law. So you cannot divorce the status of an eligible body from the activities in which it engages, because Article 132 has done precisely that.
Could I suggest something, because I would like to get closer to a practical test? I'm not saying this is correct, I just want to start the thinking. Could the test be as simple as, would the student taking the SAE course notice any material difference between what he was required to do and what he gained at the end of the day from a student who sat down in the lecture halls of Middlesex University in London? And that's a bit of a long way of putting it, but the
Yes.
question is it a question of the perspective of the student studying and what he gets out of the education and the standard, the degree and all the rest of it?
That, my lady, is one of the factors to which it is legitimate and necessary to have regard, and indeed it was one of the key focuses of the hearing before the first-tier tribunal.
You're submitting that it isn't sufficient.
It's not sufficient. No, there are more factors that must be taken into account. In the same way, but there is no red line test which will enable this court to remove from it an element of evaluation.
Yes,
that is my submission.
What it was required in addition to the student's experience and his getting a degree through the normal processes of Middlesex University. What else is required?
That is, well, the SFM factors, as you know, my lady, list a number of questions which must be asked. So, for example, being subject to the regulations of the university.
Yes, same experience.
Yes. Whether that's disciplinary requirements or not. Being entitled to attend a university degree ceremony.
Yes, that's covered.
Admitting students as members of the university.
Yes.
Having the university supervise quality standards and regulate quality standards. Providing courses which lead to a degree. The physical proximity between the college and the university is another feature. The permanence of the links between a college and a
And
university.
apart from the physical proximity, which sounds to me like a rather adventitious fact, all of those criteria could be described as simply particular manifestations of the general concept that's been put to you by my lady. Is the student experience in its widest sense the same, whether it is at Middlesex University or at SEL? These questions that you take from SFM are simply a number of ways in which you can test whether that's true or not.
I do accept that, my lord, for this reason. EC Germany was the first case in which the European Court was charged with identifying what the objective of this education exemption is. And it started immediately with the position of the student. It was there to relieve the students.
We don't have that in the authorities bundle, do we?
No,
Yes, I've
because the
missed it.
relevant paragraph is cited in our case and it's not disputed.
Well, I know, but for my part, I would find it helpful to have a copy
Certainly.
of the case.
I will arrange for that to be done, my lord. It's been noted, I'm sure.
Could you please tell me the paragraph of your case where you cite the relevant part?
Of EC Germany.
Yes.
It is cited, well, it's a paragraph 5 of our grounds of appeal at MS 30. And the, perhaps we can turn that up.
This is your original application for permission to appeal.
That's right, yes. Yes, what paragraph 5 does is to cite paragraph 47 of EC Germany, which is not contested, that's why it's not in the bundle, but I make copies.
Well, if the issue of what the objective of the exemption is illuminated by the EC Germany, we really ought to see it, whether it's common ground or not.
It's my lord may be disappointed in the sense that there's one sentence in paragraph.
That's very often the case with courts.
And the sentence is replicated in paragraph 5 on page MS 30, but we will provide the court with a copy. So yes, my lord, from our perspective, whether you look at the issue from the student's experience or whether you look at it from the college's experience or the university's experience, ultimately it doesn't matter, the perspective doesn't matter, but I absolutely take on board the point that given that the object of the exemption is to relieve students of the burden of VAT and that is the public interest that's been identified by the European Council, that perhaps a greater emphasis should be placed upon the experience of the student. I do accept that, my lady. Now, the point of this part of my submissions is to make good our case that focusing on the governance and the constitution of the respective organisations is the wrong approach. From a student's perspective, his or her experience will not be impacted by the governance provisions between the college and the university. The other reason focusing on the governance and the constitution at the cost of the activity comprising the provision of education is the wrong focus is that it ignores the fact that the exemption bites on transactions comprising supplies of education services to students. And it is artificial to divorce the governance structure from that activity.
Can I ask,
Yes.
when you look at the directive, that Article 1.3, well, first of all, Article 131, which gives effectively the subsequent exemptions and says that they're to apply in accordance with conditions which a member state shall lay down for the purposes of ensuring the correct and straightforward application of those exemptions. And then we come to 132, and I is the one we're concerned with, on MS 1750. It's tab 9, I think, in tab 9 in the authorities, page 1750. I begins in quite a straightforward way: the provision of children's or young people's education, school or university education, vocational training or retraining, including the supply of services and of goods closely related thereto. Now, if it stopped there, that would be simple. Then it adds, by bodies governed by public law, having such as their aim. And the question immediately springs to mind, why? why only public bodies? Then they add, or by other organisations, and not simply other organisations having similar objects, but other organisations recognised by the member state concerned as having. So it becomes really quite a complex provision. And all sorts of questions might be asked about the reason why different component parts are there. Has it been considered by the European Court?
It has indeed, my lord, in a case called MDDP, which I'm going to come to. But the short answer to my lord's very helpful point is that, yes, I accept this provision has a lot of moving parts. But I will come back to it if I may. But perhaps one thing to note at this stage is that the concept of a body governed by public law is a European law concept. And the discretion that is given to member states to recognise other organisations is not at large. It is constrained by European law principles such as the principle of fiscal neutrality, the principle of legal certainty, and the principle of proportionality. And it is the Zimmerman case that helps us to understand that, together with my Lady Arden's judgment in the FBT case. I will take, my lord, to the MWP case in due course, if I may. So with regard to governance, governance simply provides the legal infrastructure and management systems within which a college and a university engage in the activity of providing education. Governance structures simply regulate or manage the activity of providing education. And we say that Parliament, therefore, cannot have intended that the answer to the question whether a college is of a university depends upon whether the governance of a college is integrated with that of a university. And inquiry as to the governance structure between the respective organisations, we say, yields nothing of any real value. By contrast, the approach which we urge upon the court, which focuses on the question whether the educational activities of each organisation are integrated, better reflects the public interest objective of the exemption. As I submitted earlier, a typical student derives no obvious educational benefit from integrated governance and constitutional structures. The educational benefit derives from the fact that the college is closely associated with the university and vice versa in the provision of education. That close association cascades down to the benefit of the student. And the reason why the Horizon College case is so important, the case which provides a very broad definition of education, is that when one's asking the question, there must be a sufficient degree of integration, assuming that the court is with me on the need to have an integration test. You have to say, well, integration in relation to what? And it can only be, we submit, consistent with the public interest objective of the article, sufficient integration in relation to the provision of education, that being the activity which the European Council has exempted in the public interest. And the scope of what education means shifts and changes with every passing year. I noted that very recently a case has been registered with the European Court asking the question whether a driving school can be recognised by the German tax authorities as being a similar organisation on the basis that driving schools are educating its students as to how to drive. And that case will be heard, I anticipate, during the course of 2019.
Does that mean that what might not have been, might not have arisen as a problem on fiscal neutrality when the legislation was first enacted could become one as a result of developments in EU law or the application of mar leasing in later circumstances?
Quite so, my lady, which is why we urge upon the court a test which is flexible in its approach and which future-proofs the future development of the provision of education. Long gone are the days when teaching comprised a mortar-boarded teacher with little more than a piece of chalk and a blackboard at his disposal. And what I can say is that, with some confidence, is that the future of education and how it will be delivered is very difficult for any of us in this court to predict with any certainty, but I would venture to suggest that whatever it is, it will be as unfamiliar to us now as fax machines are to millennials. And this is one of the many reasons why we urge this court to adopt a different approach to that adopted by Lord Justice Patten, which is very much focused on the red wax seals of ancient universities, kings and nobles and aristocrats. Gone are the days when education, even higher education, is only provided in such institutions. And you have the list of the very various ways in which education is delivered in this country. So,
Well, I mean, this country has defined universities by its domestic legislation in radically different ways if you look at the way that legislation has treated it over the last 50 years. The conversion of polytechnics into universities, for example, was a major change. And one can see that this may change with the sort of institution providing education that is classified as a university.
quite so, and we've seen that very transformation. All the Act says is that the university must be a UK university, and there's a whole raft of legislative provisions as to the circumstances in which a university can describe itself.
But it looks, doesn't it, as if the phraseology used in drafting Note 1B was deliberately designed to cater for what one can loosely call federal universities, that's to say universities comprising a number of different institutions with some kind of organic connection between them. In fact, more precisely than that, it looks very much as if this was directed to the universities of Oxford, Cambridge, London and Durham.
Well, that is where, my Lord,
Hence the reference to halls and so on, which otherwise would have very little meaning.
Well, that, my Lord, is where, with respect, we must part company. It would have been a very easy drafting exercise for the draftsman to have inserted the colleges and universities you have just named into the legislation. He chose not to do so.
It's not very surprising that they chose not to do so, because universities may organise themselves in different ways over a period of time, and it was not desired to limit the category in that way. There are universities which have, so to speak, contracted out their functions. There are universities that have split themselves into a number of different colleges performing different functions, or to a number of different institutions. So it would be very surprising, in fact, if they had actually said London, Oxford, Cambridge and Durham, rather than identifying characteristics of those universities which might, at some stage, possibly already were shared by other institutions.
A number of points, my Lord, arise out of that. The first is that my Lord's analysis ignores the word any in Note 1B, any college or university. It ignores with respect the fact that Parliament has chosen not to define what it means by Note 1B, and in those circumstances it is incumbent upon this court to interpret those words by reference to their ordinary and natural meaning in context. And my third point is that the most significant context is, of course, Article 1321I. It must be presumed by this court that in enacting Note 1B, Parliament decided not to give exemption to the privileged few, but to recognise colleges, institutions and halls of universities who have higher education as their object. Note 1B is only there because of Article 1321I. And as you'll see when we get to the MDDP case, Parliament's discretion was not at large. It is tightly constrained by EU law principles. And the scenario which my Lord paints would, with the greatest respect, give rise to a breach of the principle of fiscal neutrality, because it would be inherently discriminatory, having regard to the objects of this legislation, of the EU legislation, which is to relieve students of the burden of paying a VAT. It would breach the principle of legal certainty as articulated in the MDDP case, which tells us that this court, whatever the rule is, must define a criterion of recognition which is abstract and neutral. That is to say, it must be possible for all of those who wish to assert a right to know which side of the line they fall on, or at least to know what the criteria of recognition will be. And a rule which singles out Oxford, Cambridge, and Durham is not an abstract rule, it is far from neutral, and would disable an organisation from, for example...
I wasn't suggesting that it singles them out. I was suggesting that what the draftsman had in mind by these use of these terms, which are very specific to those universities, is it's referring to universities like Oxford, Cambridge, Durham, and London.
Well, again, with the greatest respect, my lord, I disagree with that. The word institution is in there. And yes, one could describe perhaps the Bodleian as an institution. But there are many ways in which an organisation could rightly be described as an institution, certainly not limited to Oxford and Cambridge. And I make the further point, my lord, that the Finance Act 1972 uses similar words, albeit different concepts, such that my lord's observations would apply equally to the 72 Act as it does to the 94 Act. And yet, by the time we get to the 94 Act, we already have Arden University, BPP, the University of Law, Buckingham University. We already have the concept which is reflected in the very articles which were endorsed by the Secretary of State of the university in this case, which is validating other bodies to provide courses in respect of which a university grants a degree. So, in other words, my lord, the landscape had already changed dramatically by the time the 1994 Act was enacted. And we would urge this court not to adopt an interpretation which only captures the ancient colleges of the UK.
The statute is always speaking.
The statute is indeed always speaking. What is notable from Article 132 is that it does not seek to define the type of organisation which a member state may recognise. This is the point we make in paragraph 26 of our printed case, so that Parliament may legitimately recognise, which we say it has done, NGOs, charities, partnerships, limited companies, commercial providers, non-commercial providers. The note is drafted in very broad terms. What is also notable about Article 132 is that it does not single out the legal form or the profitability of an organisation as a relevant criterion of recognition. And perhaps the most profound point to make in reply to my Lord Sumption's helpful intervention is that Parliament's right to recognise some organisations and not others does not give it the right to discriminate against commercial providers, because exercising such a right would breach the European law principle of fiscal neutrality. And as this case amply demonstrates, a commercial provider of education with no constitutional links with a university is no less able to provide education to students than a charity does with those links.
Students' experience will be the same.
Precisely. Yes, my lady. Focusing on the activities of the organisation in question also has the advantage that it respects Parliament's clear intention that the college should be independent of the university, which goes to the Article 9 point we make in paragraph 37 of our printed case. This is the Nigel case, Nigl. In implementing Article 1321I, Parliament must be presumed to have intended that such organisations as it recognised should have the independent capacity which Article 9 tells us it must have in order to make the supplies in the first place. An integration test which focuses not on the narrow legal formalities of constitutions also has the benefit that it respects recital 4 of the Principal VAT Directive, a centrally important recital, which it may be convenient for the court to remind itself of. I'm happy to read it out. It tells us...
Can you give a page number?
Yes, MS 1744, tab 9. And what this tells this court is that whatever test applies, it must eliminate as far as possible factors which may distort conditions of competition, whether at a national or community level. And this feeds into our argument on proportionality. We say that the approach adopted by the Court of Appeal, which focuses on governance and constitution, promotes distortions of competition, as indeed would the scenario painted by my Lord Sumption, that only the Oxbridge or Doxbridge colleges, as we call them in our household, namely Durham, Oxford and Cambridge, would be regarded as the paradigm case for entitlement. So yes, as we readily acknowledge in our printed case, Parliament has the right to differentiate between organisations, but that does not extend to the right to discriminate such that it breaches the principle of fiscal neutrality. And we are really, this case is within those bookends, as it were, those analytical bookends. Yes, there is a discretion. Does the criterion of recognition adopted by the Court of Appeal exceed the boundaries of that discretion? And the difference between a discretion which is unlawful and a discretion which is lawful is that the criterion of recognition under consideration must be compatible with the objectives of the legislative provision under consideration. Let me give you an example. It may seem fairly facile, but I hope it proves the point. So Parliament would not have been permitted lawfully to legislate that only colleges with south-west facing windows should be entitled to claim the exemption. Why? Because south-west facing windows do not do anything to enable a student to receive education. They've got nothing to do with the public interest objective driving this exemption, which is why the object of the organisation under consideration is so central to its identification as an eligible body. Because if your object, as manifested in your activities, is the provision of higher education, and if your status has been recognised by reason of that status, that objective, then that recognition criterion is compatible with the public interest objective of the exemption. Once it becomes incompatible with it, such as the governance and constitutional structures upon which the Court of Appeal focused, then you are in the territory of unlawful discrimination. And in that context, it is, that is to say, focusing on the activities of the college, could I just ask the court to note that the business operated initially by SETL and then SEL was the business of operating private colleges of audio engineering and digital film training in the UK. And the operation of those colleges comprised, obviously, the provision of higher education to students. And the reference there is core volume, tab 8, MS 374. And relatedly, paragraph 8 of the decision letter, which was initially appealed in these proceedings, records at MS 1654 that the sale of SETL to SEL did not cause any break in the business, namely the business of teaching the students higher education. And paragraph 174 of the FTT's decision reaches the same conclusion. Conscious of the time, I'm going to take this as quickly as I can, but I want to take you now to the cases which I say support the proposition that the focus should be on the activity of providing higher education and not on governance and constitutional structures. Marley Singh and Vodafone, cited in our printed case, our integration test, focusing on the provision of education, goes with the grain of the Value Added Tax Act and is not inconsistent with any of its cardinal features. For the reasons I have just addressed you on, the same could not be said of the Court of Appeals test. My Lady Arden said at paragraph 21 of the FBT case, MS 1793, that colleges must be integrated into the university's activities for the purposes of claiming eligible body status. This is closely mirrored in the judgment of Judge Hellier in the LCC case, which is cited at paragraph 121 of the FTT's decision. And that really is worth turning up because in many ways, I say it encapsulates the correct approach. So the FTT's decision, paragraph 121, MS 221, just below line 25, paragraph 121, the investigation of this issue must encompass both what the body does, its activities, and how it or its activities are linked with the university. Whether the test is satisfied requires consideration of all the relevant facts, those in the SFM list not being exhaustive. Similarly, in the Leicester University case, my Lady Arden at paragraph 55 saw SFM factor 1, which essentially reflects the Court of Appeals approach, namely focusing on the constitutional structures, is an alternative to the broader integration test which we favour. I'd ask the court to note that the Horizon College judgment, quoted at paragraph 61 of the Court of Appeals judgment, tells us that the organisational infrastructure is but one small part of the European concept of education. The creation of an organisational infrastructure is not the public interest objective of the exemption. Which takes us to MDDP, the case which I promised my Lord Reid I would come to.
Yes, I've been reading it in the meantime. And
Yes.
it casts,
Well,
I think, a
here
rather
it is.
different complexion on the whole problem.
Yeah.
So, it is behind tab 17 at MS 1878.
It's really question one we're concerned with, isn't it? It's question one
Yes,
that we're concerned with, in fact, isn't it?
that's right. Now, if I could start, if I may, with the Advocate General's opinion, which was adopted by the court at paragraph 54 of its judgment, and just asked the court to read.
Well, it's adopted particular paragraphs of her opinion.
Yes. Let me just check that.
I think it's only adopting the statement that the
Yes, it
Advocate
is
General
indeed,
made
yes.
about the discretion of...
It doesn't cross-refer to the paragraph. The absolutely central paragraph is paragraph 70.
70?
70, yes. Paragraph 67 deals with the need for an abstract rule of recognition. This is the point I made earlier in my exchange with my Lord Sumption. And at paragraph 70, the key words at E, it is for the National Court to examine the object and conditions of MDDP's activity in comparison with Polish bodies governed by a public law providing educational services. Now, if you then go to paragraph 54 of the judgment at MS 1901, you will see that above letter E, the court adopts the same approach.
I'm sorry, where are you?
MS 1901, paragraph...
They're dealing there with question 2, aren't they? As indeed the Advocate General was in the paragraph you took us to.
Well, my concern presently is to identify the limits of the discretion ultimately available to this court, since this court is charged with supervising.
I mean, the relevant parts of the Advocate General's opinion are surely the parts which begin at paragraph 23.
Yeah.
And in particular, I mean, the significance of this is that it accepts that provision of educational services on a commercial basis is not inconsistent with the purpose of the exemption.
It's not precluded, but equally they say you can't exempt all commercial bodies providing education. And the critical issue for both her and the court, I think central passages 35 to 37, is that the commercial body has to have the same commercial or private organisations, as the court puts it, paragraph 35, last sentence. Private organisations have to have objects similar to those of bodies governed by public law.
Right.
And it's not there talking about the object of providing education, because they say you can't simply exempt all commercial bodies providing education.
Yes.
You can only exempt those whose objects are similar to those of bodies governed by public law.
Yes. But as my submission, my lord, is that you can only infer the objects of an organisation by reference to its activities. And this is my central point.
Well, you're saying that. The court is saying that it's for the member states to define the criteria by which they determine whether private organisations do or do not have objects similar to those of bodies governed by public law.
The context of MDDP was difficult because the Polish government had chosen to permit all providers of education to claim the exemption. That then gave rise to a conundrum with which the court grappled, namely, what is the role of the national court in such circumstances? And it was in that context that it came up with the guidance that any rule determined by the national court must be neutral, abstract, and defined in advance, because the concern of the court was that if, contrary to that which was anticipated by Article 132, the national courts were left at liberty to decide on a case-by-case basis as to whether any given organisation was entitled to the exemption, then legal certainty would be lost, and no one would be able to predict whether they were in or out, because each case would turn on its own facts.
I mean,
Now,
you might be submitting, but I don't want to put words in your mouth and misunderstand your case, that the answer to Lord Reed's point is that this is an exemption for a particular kind of service rather than a particular kind of institution. And so when the MDTP talks about the having purposes similar to that of the university,
No, objects.
objects similar to that of the university, one's only concerned with those of its objects which are relevant to the particular service that's exempted, viz. The provision of education. I mean, is that what you're saying?
that is precisely, these are the paragraphs I would like to take the court to. That is exactly my submission. And the relevant paragraphs, if I may, are, first of all, paragraph 70 of the Advocate General's opinion, I still maintain.
Sorry, paragraph 70.
70.
Before we leave Lord Sumption's point, if you look at paragraph 36...
Of the opinion, my lord.
Yeah, of the judgment.
Of the judgment.
The court's telling us there that an exemption which applies generally to all supplies of educational services, whatever the aim pursued by the private organisations providing those services, is incompatible with the directive.
Quite, because Poland had failed to exercise its discretion lawfully by failing to exercise it.
Yeah. So
It hadn't done anything.
It follows that failing to treat commercial bodies providing educational services as a whole in the same way as public bodies providing those services is not a breach either of the principle of equal treatment or of fiscal neutrality.
No.
It can't be.
No, that's
Similarly, the word aim, which is, I think, another way in which, in the same judgment, they're trying to explain the meaning of the concept of objects,
Yes.
doesn't just mean the provision of higher educational services.
Yeah.
no.
It must be pointing at something else that must be, if you like, broadly similar to that pursued by a public body, which would justify the exercise of the discretion in that direction.
Well, in the context of the higher education exemption, the words in Article 132 are having such as their aim. And what the Council does is to identify different types of organisation, children and young persons' education being one, higher education being another.
I mean, the objection of the court to the Polish arrangement seems to have been that it was indiscriminate.
Yeah.
And, I mean, they I think, expressly recognised, I'm trying to remember where, that this particular institution might well have qualified under a more narrowly framed Polish exemption. The objection is not to the idea that the real problem is that they haven't actually, the Polish legislator hadn't applied his mind to the kind of educational services which should be regarded as comparable to those provided by a public law university, because he had simply produced a blanket exemption of everybody providing education without making that distinction. Now, the Polish legislator might well have concluded that all educational services of the kind possible in Poland were in fact equivalent to those provided by a public service institution. But I think that the real point that they are making is that the legislator's got to apply his mind to this question, and the Polish categorization was too broad to be consistent with that.
Precisely. But then that gave rise to the difficulty as to how you deal with such a legislative vacuum. Do the courts step in and identify their own criterion of recognition, or is there another solution? And what the court ultimately did was to acknowledge that the national courts could indeed step in for as long as their criterion of recognition was not based on a case-by-case basis, but was based upon a neutral, abstract rule which they defined in advance. That was ultimately what the court found. And it is in that context, namely the context of the national court performing a role, which ultimately is the same as the role this court is discharging, albeit with a different legislative context. It provides guidance as to how the national court must approach the question.
But you're not submitting that we're directly performing that role, are you?
No, you're not.
We're
You're
only performing the
supervising.
role because we have to construe what Parliament has done in doing that job itself.
Precisely. So there is that intervening step. At least there's some legislation, whereas in Poland there was
Yes.
none. But nevertheless, the court was given the power to recognise. And this is why paragraph 70 of the Advocate General's opinion, in the context of my submission as to what the scope of the test is in this case, is so central, because what you see from paragraph 70 is a focus on the activity of the organisation as compared with the activity of the public body.
I mean, the English legislation, the UK legislation, effectively recognises all UK universities as exempt bodies. So it is invoking a category that is defined by English domestic law. The problem that we're concerned with is a different one to the one that was in the mind of the court when they were looking at MDDP, namely, given that all universities are exempt, what has to be the relationship between an education providing body and a university in order that the extension should extend to it? That's not an issue which I think is even indirectly covered by MDDP, except that it does, interestingly, make it clear that the commercial basis of the provision is not the touchstone.
I entirely accept that, my lord. But one can glean from both the Advocate General's opinion and the judgment some guidance which is relevant to the task which this court has discharged. And the context of this submission is our case that the focus should be on the activity, the integration of the activity, and not the governance structures of the college and the university. And that's what you get from paragraph 70 of the Advocate General's opinion and paragraph 54 of the court, which again talks about the provision of educational services. One gets the same point, conscious of the time, from paragraph 35 of the judgment, which talks about private organisations having to fulfil the condition of pursuing objects similar to those governed by public law. Paragraph 39, one must look at the objects pursued by non-public organisations. And paragraph 55, the question is whether the objects pursued by an organisation can be considered to be similar to those pursued by a body governed by public law.
I mean, obviously, this affects what we ought to be considering, because or it may, because the Parliament has identified universities, and in the phrase we find in Note 1b, as bodies whose objects are similar to those of bodies governed by public law. And one can understand there's quite a close similarity, or many points of similarity. I mean, for example, universities will be constituted by a royal charter or under statute. They will have objects designed for public benefit. Most of them will have a charitable status that reflects the object of benefiting the public, and so forth. So the analogy between a university and a public body is quite a close one, and that analogy would hold good for a college or institution, or it is presumably intended, Parliament's intention is presumably that the same should be true of the colleges, institutions, etc., of universities which are within Note 1B. And if that's right, then we might be needing to ask ourselves, well, is SEL in that position?
If I may respond to one point my Lord made, which is the status of bodies governed by public law, and the suggestion that universities, by dint of their being recognised through Acts of Parliament or orders from the Privy Council, are in an analogous position. They are not, my Lord, with the greatest respect. The University of Cambridge case, which is cited in our grounds of appeal, tells us that the University of Cambridge is not a body governed by public law because it is not part of the fabric of the state.
No, of course
The
not.
concept of a body governed by public law is a freestanding EU law concept.
Which applies to virtually no universities
Well,
in the UK.
Well, for example, there are no universities governed by public law in the UK. But, for example, the German case, which has just been registered, is concerned with a public university.
Yeah,
But the point...
Well, it's left to, we're told it's left to the member states to, the word definition is used in one of these paragraphs, that it's up, effectively, I can't see the paragraph at the moment, but it's for the member states, here, it's 137. The directive doesn't specify the conditions or procedures for defining those similar objects, that is, similar objects to those of public bodies. Yeah. So it's in principle for national law to lay down the rules in accordance with which that definition may be granted to such organisations. So Note 1B is a rule in accordance with which that definition has been granted to universities in the UK. Now, I don't know if you were able to help us with what the condition or criterion is on which Note 1B is based, which we can then ask ourselves, does that apply to SEL?
This is the point of this part of my submissions, my Lord. This is the point I wish now to develop if I could. But could I just pick up one feature of the paragraph you just read? The 6th VAT directive, at least the English version of it, talked about member states defining other organisations. Article 132 talks about recognising. So that's the explanation for the reference to defining in that case, because it was referring to the, well, it's confusing because of the translation service in who knows how Poland has implemented the directive.
Yes, because they're referring to the same directive as we're concerned with.
They are indeed, but it's just the word defining that I'm concerned about.
Is there a UK legal definition, statutory or otherwise, of a university?
No, I've looked into that. There are a number of ways in which a university can be recognised, one of which we see in this case, which is an order from the Privy Council. So no, there is no catch-all category. And there are many statutes and regulations which govern your right to claim to be a university. So that, for example...
Well, that may well lead to a definition.
Yes, ultimately, yes, but via lots of different routes.
Well, there may be an administrative process involved in identifying a university, but does your printed case or any of the material before us identify what the statutory provisions are which govern the right to call yourself a university?
No, they do not, my Lord. We'd be happy to assist the court with that. We didn't do it because it's common ground that Middlesex University is...
Well, I would find that of assistance.
Yes, certainly. That has been noted, and we will provide a written note to the court. Would that...
I would find that helpful,
yes.
And if it's common ground, no doubt you can agree it between you.
Yes, certainly. So if I may go back to my core submission as to why the Court of Appeal's approach is too narrow and formalistic. That takes us to the case of Gregg, which is dealt with extensively in our case. I won't repeat it. Paragraphs 16 to 19 and paragraph 38 to 44. And what this feeds into...
Sorry, can I have an opening page number for all that? A page number for all that?
Certainly. I apologise. So, paragraph 16 to 19 of our printed case.
Oh, I see. You're not referring to anything in the
No, I'm
authority,
just
you're referring to your
it.
case.
So it's paragraph 16 to 19 and 38 to 44 deal with the case of Gregg, and why it is that a narrow and formalistic approach which looks at the legal infrastructure of a provider of, in that case, social welfare services, is the wrong approach because it's incompatible with the public interest objective of that particular exemption. That was a case in which the Greggs claimed not to be an organisation because they were a partnership, and a partnership has no legal personality. Therefore, they could not be an organisation, to which the European Court said to adopt such an approach would run contrary to the public interest objective of the care services exemption under consideration. And this feeds into the point I made earlier about recital 4, which is that that does not achieve the objective of doing the least possible damage to European law principles. It does the opposite, and we make the same submission with regard to the Court of Appeal's approach. So the court found in that case that the legal personality of the provider of the care services is really nothing to the point. The BDV case is at tab 14 of the authorities bundle, MS 1821. The relevant paragraphs are set in paragraphs 13 and 25 of our printed case. It's an Article 131 case, namely whether the Member State had laid down conditions to ensure the correct and straightforward application of the exemption in that case. The key paragraphs, from my perspective, are paragraphs 28 to 30, which effectively urges this court to adopt a test that causes the least possible detriment to the objectives and principles laid down in the Principal VAT Directive. And under Mar-leasing principles, this court must presume that Parliament intended for Note 1B to cause the least possible detriment to the public interest objective. Shared governance or constitutional structures do not in themselves serve to further the objective of improving student access to higher education. Garage and Mollenhyde, cited at paragraph 25 of our printed case.
Can I just interrupt you before you take
Yes.
us to it? I see at paragraph 23 you cite the Open University case as one where there was some discussion of MDDP and the need for some abstract rule of recognition of
That's right.
appropriate bodies. It might be helpful for us to have access to see that case.
Yes, that has been noted. It's a very short paragraph. The Chancellor expressed concern that the aspect of the case with which this appeal is concerned had not been explored as intensively as he would have liked in that case.
Yeah.
That's effectively what he is saying.
Yeah.
So Garage Mollenhyde, paragraph 25 of our printed case, it's a similar case to the BDV case, namely seek to achieve the least possible detriment to the public interest objectives of the exemption. Town and county factors, the same point in a sense, which is, that's the case, paragraph 11 of our grounds of appeal under ground 5. That is the case that says that it matters not whether an organisation or whether a contract is binding in honour only. It's still a legal relationship. The focus must be on the activity that's under consideration. Secret hotels, this is the the last of the run of cases I wish to refer to. I'm conscious of the time, so I won't turn it up if it's convenient for the court, but it's at the Authorities Bundle, tab 13, page 1802. And what I'd ask the court to note, that this was a case in which the characterisation of the particular transactions under consideration in that case did depend on the formal contractual arrangements. And you see that from paragraph 23, 31, 34 and 55 of Lord Neuberger's judgment. But we know from the Gregg case that with regard to this public interest exemption, that such considerations are too narrow and legalistic, having regard to that public interest objective. So our case is the opposite. But even in a context in which the Court of Appeal recognised in secret hotels that the contractual arrangements were key, the court still urged deference to common sense and commercial realities. So even in that context, the contractual arrangements did not necessarily reign supreme. If I could just, as quickly as I can, just clarify our case with regard to legal certainty. Our case is not that an evaluative test can never meet the principle of legal certainty. That is manifestly not the case, since the VAT system is full of evaluative tests. Our case on legal certainty is that the manner in which the Court of Appeal has articulated the test breaches the principle of legal certainty. With regard to proportionality, our case on proportionality is not circular. It is rooted in recital 4 of the principal VAT directive. And what it does is to contrast integration, which is founded on the activity of providing education on the one hand, with the Court of Appeal's approach, which focuses on the formal constitutional and governance structures on the other. And we say the latter approach is disproportionate because it goes further than is necessary to achieve the public interest of this exemption. Fiscal neutrality, before I quickly move on to the third area, which is why the first-tier tribunal was right or was entitled to find that my clients met the integration test. Fiscal neutrality manifests itself in many ways. The first type, I'm going to give you 3 types. The story's not over. The court will come up with other illustrations of the principle, but I'm just keen to ensure that this court anchors itself in the version of fiscal neutrality upon which we rely. We do not rely on the first type. The first type of fiscal neutrality, set out in paragraph 47 of the Zimmerman case, is the rule which is inherent in the VAT system, reflected in recital 7, that businesses should not carry the fiscal burden of the tax, because the tax is a tax on consumption. Businesses do no more than collect the tax on behalf of the tax collecting authority, the consumer taking the fiscal hit of the tax. That's why it's a tax on consumption, and that is achieved through the input tax deduction mechanism. And that is a principle which must be respected. So that's the first sense in which the principle of fiscal neutrality is used. The second is when materially identical supplies are treated or are subject to different treatment. That is paragraph 48 in Zimmerman. That was the type of fiscal neutrality that was engaged in the FBT case. The college in that case was seeking the benefit of the all or nothing rule in the same way in which universities sought the benefit of the all or nothing rule. And in that context, the compensation mechanism for equalising distortions of competition which arise from such discrimination is built into the VAT system itself. We never got to compensation in FBT because they didn't get past the first hurdle. But the point of this particular type of fiscal neutrality is that it is a type of overt discrimination, relying upon that type of fiscal neutrality in the context of this sort of case, where the boundaries of the test are at issue, will always be circular. And that's why we do not rely upon that type of fiscal neutrality, because the very question which this court needs to determine is what is the test. The type of fiscal neutrality upon which we rely is the type that is articulated in paragraph 20 of the Gregg judgment, is it is a form of indirect discrimination. The gist of which is that the principle of fiscal neutrality, as articulated in type 2, would be frustrated if recognition criteria which are incompatible with the objectives of the legislation are treated as determinative, an example of which is a recognition criteria that is too narrow and formalistic. And the point here is that if the recognition criteria under consideration, such as the Court of Appeals test, is inherently discriminatory, it is the equivalent of the advert from the constabulary saying only those over 6 feet tall need apply. It can't be that easy to subvert the principle of fiscal neutrality. And our core submission in this context is that the constituent part of test is inherently discriminatory, not just against my clients, but against all commercial providers, because typically commercial providers will not be part of the governance structure of the university with which they are providing higher education. So they will never be able to pass the test. So like in Gregg, no partnership in England and Wales and Northern Ireland would be entitled to the exemption on the basis that it was an organisation, because partnerships lack legal personality. That is a rule of recognition which is inherently discriminatory and which distorts competition and does not meet recital 4 of the principal VAT directive. So it's type 3 that we are concerned with. That type of fiscal neutrality is not, contrary to what is said by HMRC, a circular argument. Now that takes me, very conscious of the time, my lords, I have 2 minutes in which to address the third of the points I wish to...
You have provided us with a very full and very helpful written note, so obviously we will take that fully into account. But if you want to use your 2 minutes to highlight any point...
Yes. So, thank you. I'm very grateful for that. So, the printer case sets out our case extensively on this. But what I'd like to draw to the court's attention, which perhaps doesn't come out as much as it should, is the extent to which the students and SEL were bound by MU's regulations in the division of education. And I think the best I can do, given the time, is to give you the paragraph numbers. The point here is that SEL, for the reasons set out in our printed case, is not just a course provider. We know, this is fundamental, and it is common ground, that SEL does not provide courses to the university, it provides education to the students. That's why it has been assessed by HMRC. So the notion that SEL is providing courses to the university which then provides the education to the students is, with the greatest respect, a nonsense. It is common ground, see paragraph 41 of the Upper Tribunal's decision, and paragraph 34 of the Court of Appeals judgment, that SEL provides education to the students and does not, see paragraph 34 of the Court of Appeals judgment, provide education through the university. I would suggest that the best response to the submission that SEL does no more than provide courses is Dr. Butland's letter at part 1D MS 1498. I would invite the court to read that in full. Moving on to the regulations, if I may give you the relevant references. Part 1B, MS 522, clause 6, deals with admission regulations. MS 858, the regulations govern the composition of the assessment board. Part 1C, MS 1053, this deals with the validation of the London campus, from which you will see the obligation to comply with MU regulations. The same is true of two other validation documents, 1C tab 12 MS 1244, and the student entitlement sheet at 1C 13 MS 1270. The FTT's decision at paragraph 247 talks about SEL operating within MU's overarching regulatory framework. At paragraph 103 of Professor Hitch's witness statement, he says in terms, this is at MS 1425, that until 2010, all programmes were run under MU regulations. That was confirmed to HMRC at MS 1502. And finally, this will take me less than 30 seconds, could I please give to the court the paragraph numbers of the witness statement of Professor Klitsch, which deal with the extent to which SEL was subject to MU's regulations, and they are as follows: 24, 37, 45, 49, 95F, 95G, 95H, 103, 127, 130B, 150, 151, and 154. And we say that the documents to which I have drawn the court's attention demonstrate conclusively that SEL is doing far more than providing courses to MU subject to its regulations with regard to the delivery of higher education. So those, my lord, my lady, are my submissions, unless I can help you with anything.
Thank you very much, Ms. Hall. Ms. Kelsey, do you follow?
No, sir, nothing further.
Mr. Singh.
My lords, my lady, my submissions in summary are that, one, the UK has a discretion under the Principal VAT Directive as to which organisations it recognises as having similar objects to bodies governed by public law which have the provision of university education as their aim. Two, the UK has lawfully exercised its discretion by recognising only those organisations which are universities or parts of universities, so long as the part is a college, institution, school or hall. Three, as is common ground, SEL is not a university or a part of a university. Four, therefore, the Court of Appeal was right to conclude that SEL did not benefit from the exemption. And five, finally, if a looser approach to exemption of the kind advanced by my learned friend is appropriate, contrary to my principal submissions, SEL still does not benefit from the exemption. So I will develop those points as follows. So may I take you first of all to the Principal VAT Directive. That's MS 1750. And just for your information, the terms of the exemption were materially the same in Article 13A1 of the 6th Directive, which you have at MS 1742. If we have a look at MS 1750, you can see that Article
1750.
1750, my lord, 1750. So you can see that Article 132 is headed exemptions for certain activities in the public interest. And then Article 132. Sorry,
do you mean 1715? I'm not on the right page.
1750.
Ah,
Yes,
sorry. Right.
Yeah, so we have exemptions for certain activities in the public interest, Article 132, and then 1, member states shall exempt the following transactions. And then if we move down to I, the provision of, let's just focus on university education for our purposes, the provision of university education by bodies governed by public law having such as their aim. Now, just pausing there, the provision of university education by those bodies is assumed to be in the public interest. Those bodies do not require any kind of exercise of member state discretion to benefit from the exemption. The wording then goes on as follows: or by other organisations recognised by the member state concerned as having similar objects. So these are similar objects to bodies governed by public law having the provision of university education, in our case, as their aim. Now, as is common ground in this appeal, and as was decided in the Cambridge University case, which was referred to by my lady in FBT, you'll reference MS 1795, UK universities are not bodies governed by public law because they're not considered to form part of the public administration of the UK. UK universities could therefore only benefit from this exemption if the UK recognised them as other organisations. And the UK has recognised them through its domestic legislation. May I ask you to go to MS 1722? Here we have the education exemption set out in Group 6 of Schedule 9 to the VAT Act 1994. And you can see that it begins, MS 1722, Group 6, Education, item number 1, the provision by an eligible body of A, education. That's the bit that we're concerned with. And then if you move on to have a look at the notes, notes 1, for the purpose of this group, an eligible body is, and then we turn over to look at B, a United Kingdom university and any college, institution, school or hall of such a university. Now, in my submission, the ordinary and natural meaning of these words in note 1b is straightforward. Of, the word of, is used here to mean part of. So the wording covers a UK university and any part of a UK university, so long as that part is a college, institution, school or hall.
Well, why did Parliament need to do that? Because it's tautologous, it's all within university.
Lady, that was the point you made in the Leicester University case, which I was just about to come to. But before I do that, I did want to just point out that the Court of Appeal has twice held that of is to be constructed as part of, in this case and in the Leicester University case. And may I take you to 1779?
Just so that I can follow the argument. What does it mean to say that an institution is part of a university? Now, I understand from your printed case, obviously you support the Court of Appeal's view, that that means a constituent part of. What is a constituent part of a university? Does it mean that the alleged college has got to be part of the governance arrangements of that university? And if not, what's the test?
Well, my lord, I say that it has to be the part, say the college, is a part if it is recognised as such, so recognised as a college in the university's constitutional documents. So whatever they are...
If it's called a college of the university,
yes,
then it doesn't matter what, in other respects, its relationship with the university is.
Yes, that is my submission.
But that would appear to mean that universities can conclusively confer collegiate status for the purpose of the VAT Act on anybody that it likes, which is concerned with the provision of education.
Well, Lord, the university, it's a university's prerogative as to which body it confers collegiate status on. There will be regulatory requirements and so on in order for a college to be treated as of a university. Once the university has done that, we have the satisfaction of our clear hard edge test, There's no need to get into discretionary matters which were disapproved of by Advocate General Cockott and MDDP, as we look at. And then we have a body which is treated as part of the university. So I say if one has the constitutional link, and the university is saying in its own constitutional documents, which are not insignificant documents, that an entity is a college of it, as Oxford does, for example, in its statutes, that is conclusive. And that means that the college is to be
So
treated.
there are no objective criteria, it is simply what the university chooses to call a college of the university.
Well, my lord, the objective criteria would be what does the university's constitution say? What do the constitutional documents disclose? They would indicate all of the entities who are colleges of a university. So, for example, Oxford amends its statute to incorporate a new college, which it did. I was going to say recently, it's not recently now, but it did it with Harris Manchester, for example. So if one looks to the university's constitutional document and sees the body listed there, and the university has then gone through the trouble and the effort of ensuring that it is recognised as a part, I say there we have the constitutional link, and the body is then a part of that university.
Can I just be clear? You say that a body, whether it's a college, institution, school or hall, is part of a university if, always if, and only if it is recognised as such, that is, as part of the university, in the university's constitution.
Yes, my lord.
Irrespective of what role it plays in the university's affairs.
Well, my lord, if it's I say that's all implicit in the recognition by the university.
What's implicit? That it will
Yes.
have some role in university affairs?
Well, my lord, if the university has gone to the trouble of recognising it in its own constitution, it's implicit that the university sees it as part of the university. And we have to assume universities are acting in good faith, they're regulated bodies, they're not going to seek to abuse the exemption. That's a separate matter. We say just as a matter of how to qualify as a part, what is necessary is a constitutional link. And that was one of the points made as long ago as in the SFM case by HMRC. So what HMRC said there is that it is a crucial feature to have a foundation document of some kind establishing the entity as a college of the university by way of constitutional link.
I mean,
HMRC have
some
maintained that
universities-
line ever since.
Not all universities have a constitution with a capital C, so to speak. In some cases, the way that a university is organised will be apparent from a number of documents, decisions of a governing body and so on, but will not be apparent if it's a chartered university from its royal charter, for example.
Yes.
So what are you referring to as the constitution? The general corpus of rules about the way that the university is organised?
Well, my lord, the university will have some kind of foundation document. If it's not a constitution, it will be in some other form.
So if it's a chartered university, are you saying that it's got to be, the college has to be identified in its charter? The charter of the university?
Yeah, well, Lord, in order to be a part of, yes. If a new entity wants to become a college of the university, it may be necessary for there to be a new charter, but it has to be recognised in the university's foundation documents. I do say that, my Lord.
Recognised as what?
As a college of the university. Oxford has no problem in doing this. If one looks at the statute, Oxford says these are the colleges of the university, and then it lists them.
Well, Oxford doesn't have a foundational document because it was founded well before such things came into existence.
Yes, but it
There's
has
no royal charter.
It has statute.
It's essentially a self-governing body of scholars who make rules among themselves.
Well,
But that's not a foundational document. That's just the result of successive decisions.
Well, my Lord, as Lord Justice Patton put it in this case, what is crucial is the legal relationship, in whatever form it's reflected in. So it doesn't really matter.
Exactly. That's why I question your emphasis on a foundational document,
Well,
because universities may be created in a variety of ways, more or less formal, and what they are, what bodies consist of part of them, may be governed by all sorts of legal instruments which are not foundational documents.
Yes, and also there would be a degree of flexibility about tying it to the foundational document, because new schools and institutions get created from time to time.
Yes, my lord, foundation document was just my clumsy phrase for the university's the crucial documents in which any legal relationship of that importance would be reflected. So it may not be a foundation, it may be something else, some other constitutional document, some other form of document, a statute, whatever. The form doesn't matter. What matters is that the legal relationship is reflected in it.
But then legal relationships could be created by a perfectly private contract between the university and, in this case, the appellant.
Yes, well,
why would that not be a qualifying
well,
document under your definition?
Lord Justice Patten left that open, and it may be, but so long as the university is recognising all of its other colleges in the same way, so it's treating this college as being on an equal footing with the other colleges, because that would indicate that it is seriously a part of the university. So if, for example, the university has a document which lists all of the colleges that are a part, but for some reason it has some other, say, a mere contract as opposed to a constitutional document with some other entity, then it would be difficult, I say, to treat that other entity as being on the same footing as the parts of the university.
Are you submitting that there has got to be a document which says, a document which is part of the constitution in the broadest sense of a university, which says the X institution is a college of this university, or is it enough for the constitutional document in question to describe a relationship with the X institution which the court will recognise as making it part of the university?
My lord, I would say the latter. Obviously, if it's the former, it makes it easy. But if it's the latter, then that is all that's required.
Well, I'm inclined to agree with you. Now, suppose that the relevant legal documents of the university say the X institution shall be entitled to admit students to this university, and those students shall be treated as students of this university and shall be eligible for this university's degrees. Now, I think it's got to be your case, since those are characteristics of SEL, that isn't good enough.
Yes.
I wonder why not.
Well, my lord, in SEL there are a whole host of other reasons why SEL doesn't qualify. So we would say that doesn't go far enough. It doesn't actually constitute the college as a part of the university.
Well, it's a relationship, isn't it? I mean, if an institution has the right to admit students to a university, that would seem to me to be a really very strong indication that it has a relationship with the university that makes it part of it.
But, my lord, it may just be a partnership type relationship. It doesn't necessarily have to be a relationship as tight as the word "of" indicates. It may not be that tight. I mean, the reason why we get to part is because we are trying to work out what "of" means. "Of" indicates a very tight nexus indeed, and having something that you describe may not actually meet the tight nexus.
So what characteristics does the relationship, given that you accept it doesn't have to say it is part of the university, it can identify a relationship which the court recognises as making it part. So what should we look for? What are the characteristics of the relationship that the court will recognise as making the X institution part of the university?
Well, my lord, ordinarily, if an entity is referred to in the constitutional documents as, perhaps one way of putting it is belonging to the university in some form, forming under, perhaps forming part of the governance of the university, that kind of thing. I mean, my approach on the basis of the Court of Appeal's decision is that the primary point is that it does need to be a part of, and it should be possible to work that out. That should be something obvious from looking at the document in which the legal relationship is expressed. Because once we get to things like, well, what characteristics are needed, we're then veering back into the SFM factors, and we're getting further away from legal certainty.
Well, the trouble is that the elephant test is possibly the least certain test one can imagine.
I'm sorry, my lord, the other...
You know an elephant when you see it
Yes.
is not a very satisfactory definition. I mean, I just put this thought to you for you to reflect on. It would seem to me, right at the moment, that there can be two kinds of relationship that may suffice to make someone part of the university. One is a governance relationship. The ex-institution contributes to the governance of the university, the way that, as I think I'm right in saying, colleges of Oxford University do, but halls of Oxford University do not. The other possible test is that the ex-institution has the power to admit students to the university and thereby to qualify them to postulate for the university's degrees. Now, there may be a third kind of relationship, but those are the two that strike me as calling for consideration. Now, I think your last answer suggested, but you may want to think further about this, that it had to be the first of those two kinds of relationship, and the second wouldn't do.
Well, my lord, it's difficult to be too prescriptive about the various circumstances, various kind of conditions of relationship that may qualify a university to be part of, a college to be part of the university. So our approach is part of is the test. I will need to think more about the kind of characteristics that could qualify a entity as being part of the university, which I can do over the lunch adjournment.
For my part, I think that actually is at the heart of this case.
Yes. I mean, I had taken it to be kind of the elephant test, essentially, that you know a part of, well, when you see it in the university's constitutional or other documents. But I will think a bit more about the kind of characteristics necessary. Yes.
What about HMRC guidance?
So, my lady, HMRC guidance at the moment is based on it was based on SFM. I think still is, because it was only in the Court of Appeal in this case that there was a move away from the SFM approach.
HMRC has been content to operate that.
I don't know if they've been operating it, my lady. I'll have to check that. I don't know
I'd
if
be
other
grateful
cases,
to know.
But they didn't in this case.
I don't know if
Presumably they're
it's been
awaiting the
staying.
outcome
Yes, I think
of the present
cases
appeal.
may have been waiting the outcome of this
But
case.
for many years, it operated
Yes.
with documents like 0311.
Yes, but not necessarily without problems, maybe. So as we saw in this case, we had a hearing of 6 days in the first-tier tribunal to try to work out if a body was eligible for the exemption. When we got to the upper tribunal and HMRC were alleging that there was an error of law in the first-tier decision, Malone Friends' approach was, well, below HMRC, they had some good points, we had some good points. It was open to the tribunal to decide in our favour. They could have decided in HMRC's favour. So it makes
The oddity of this whole case is that the original decision letter, which we ostensibly this appeal arises out of, was based on a proposition that no one now seeks to defend, namely that this was a profit-making body.
But when you say no one seeks to defend it, my lord, it was raised by SEL. It was their main ground of appeal until August 2011. They eventually accepted...
MDDP put paid to it.
I'm sorry, my lord?
MDDP's decision, the decision in MDDP put paid to the...
They withdrew their claim before MDDP, my lord. It was withdrawn on the first day of the hearing before the first-tier tribunal. So that was no longer pursued because they accepted, based, for example, on my lady's decision in Messenger Leisure, that there were covert distributions of profit, as alleged by HMRC in their statement of case.
But that's no longer an issue.
It's no longer an issue because SEL are no longer pursuing the claim, my lord. That's why it's no longer an issue, and they haven't pursued it since the first day of the hearing in the FTT. Yes.
Do you accept that whatever test you give to us must comply with the European law principles of proportionality, certainty, fiscal neutrality?
Of course, my lady.
So you have to demonstrate.
Yes, I accept all of that, and I'm going to come on to them.
And it would be, in case of fiscal neutrality, have something to be tested in the circumstances of the modern supply of services of education.
Well, my lady, I'll come on to that when I go to your decision, your judgment in FPT. We can look at that in a bit more detail.
It also has to be capable of straightforward application, according to Article 131. It's a challenging task to try to meet all these requirements.
Yes, it is.
By definition, anything that's the subject of an appeal here is not capable of straightforward application.
Yes, although we have to try to think of a test that is, and I do submit, and I will go away
6 days of evidence isn't straightforward.
and think about the characteristics. But I would say the part of test is considerably more straightforward than the test that we had up until the Court of Appeal's decision in this case. So I was going to take you to Lord Justice Peter Gibson's decision in Leicester University. So that's in the authorities bundle, and it is page 1779.
1779.
Yes, 1779. And paragraph 36. So Lord Justice Peter Gibson begins by saying, Note 1B on its face refers to 5 entities, a UK university, and 4 entities of such a university. He then says the conjunction connecting a UK university with the 4 other entities is a word and, not including. So the point being made there is that those are the only entities referred to. And that was a relevant issue in this case because it was suggested the students' union could potentially qualify as an institution. And then he says, further, the 4 other entities are alternative to each other, as can be seen by the conjunction or between school and hall. On the ordinary and natural meaning of the words used in Note 1B, I would construe them as covering both the university itself and, in those cases where there are separate entities which are nevertheless parts of that university, any of those separate entities. Now, what I was now going to do was go on to Milady's objection to the construction of as part of, but it's 2 minutes to 1. I don't know if
Yes,
you want to...
there is a convenient point.
Yes, thank you.
Well, the court will adjourn.
Thank you.